Hello aspirants, welcome to Spardha Line. We are continuing with our series that complete Indian polity through MCQ. So in this session, we are going to see the Supreme Court as well as the High Court. So all the questions, the important content related to Supreme Court and High Court, we are going to see through the MCQs. So we are not just solving the MCQ, but we will build the content. I will tell you the gaps, the hidden facts. I will make you to how to read between the lines. Everything I will be giving through this session. So we'll start with our first question. So this first question is about the judicial system and the Supreme Court in India. Okay. So first question statement says that India follows a single integrated system of court adopted from the Government of India Act 1935. Then second, the Supreme Court of India was inaugurated on the 28th January 1950, succeeded the Federal Court of India. Okay. Then Supreme Court of India replaced the British Privy Council is as the highest court of appeal. So now the three facts are there. Okay. So we all know we have adopted single and integrated system of court, and that was given in the Government of India Act 1935. Okay. So there are two types of court, judicial system. First, okay, one type is integrated. Okay. Second type is double. This double judicial system. Okay. So when it comes to the integrated, what happens? This particular integrated judicial system, here we see, when it comes to integrated judicial system, we see the Supreme Court at the top, then the High Court, then we see the subordinate courts. Okay. And so along with subordinate courts, there would be various tribunals, and these tribunals would be working under the High Court or the below the High Court. So this is called integrated judicial system. Why it is integrated? Because if you are filing case in subordinate courts, okay, subordinate court, if you are going to subordinate court with some case, so if the subordinate courts give certain judgment and the judgment is not in your favor, and or you find that the judgment is injustifiable, so what you can do? You go for the High Court with appeal. Okay. And same happens High Court. High Court also not satisfies you, then you can go to the Supreme Court. So this is because from the lower court you can go to higher court. So that's why it is called integrated judicial system. And when it comes to double judicial system, we know there would be Supreme Court, okay, or it is called Federal Court also, Federal Court, and the below the Federal Court there would be High Court. Okay. And this double judicial system, because the High Court and the Supreme Court, okay, they are not subordinate. High Court is not subordinate to the Supreme Court, but when it comes to integrated judicial system, High Court is subordinate to the Supreme Court. But here you may find these both courts have the independent existence. Okay. Now this particular system is followed in USA. So when in USA there is High Court for every state, and High Court is the highest court of appeal in the all the states. Only the constitutional matters you can go to the federal courts. Okay. Or High Court decides it is unjustifiable, then only you can go to Supreme Court or the Federal Court of USA, and that too only in constitutional issues, not in other issues. So when it comes to criminal issues and civil matters, that time the High Court becomes the highest court there. But in this case, what we say, you let it be constitutional, civil, criminal, you can go till the Supreme Court here against the judgment of the this High Court or the subordinate court. So this is the fundamental difference between the integrated and the double judicial system. And this integrated judicial system we have taken from the Government of India Act 1935. Then the Supreme Court of India was inaugurated on 28th January 1950, and it succeeded Federal Court of India. Yes, we know the Federal Court of India. It was established under this Government of India Act 1935, and through this Government of India Act 1935, what they established? They established this Federal Court, okay, as the court, integrated court for India. Okay, so that's why and our Supreme Court on 28th January when it established, it succeeded Federal Court. Okay. Second, the Supreme Court of India replaced the British Privy Council is the highest court of appeal. Yes, because in the British time there was a system. Okay, so there were the subordinate courts. Okay, subordinate courts. Above the subordinate courts there used to be high court. Okay, at provincial level there used to be high court. Above the high court there used to be federal court. Okay, and above the federal court there used to be this British Privy Council. Okay, British Privy Council, and this British Privy Council was made up of the House of Lords, the members of House of Lords. Okay, so now the against the judgment of federal court, you had the right to go to this British Privy Council. Okay, so technically the British Privy Council was the highest court of appeal during the colonial time. But what happened when Supreme Court came in existence? The Supreme Court became the highest court of appeal. So that's why it replaced the British Privy Council. So the third statement is also correct. So correct answer is here D. That 1, 2, 3 all are correct here. Okay. Then next question we'll see. So next question, it is about the appointment of judges of Supreme Court. Okay, so see the statements carefully. First statement, the judges of Supreme Court are appointed by the President and on the recommendation of the Council of Ministers. Then the Chief Justice of India appointed by the President after consultation with the such judges of Supreme Court and High Court as deemed necessary. Then consultation with Chief Justice of India is mandatory for the appointment of Supreme Court judges other than the Chief Justice. So let me know which one is the correct here. Then we'll discuss briefly. Okay, so see the first statement, judges of the Supreme Court appointed by the President on recommendation of Council of Ministers. Technically statement is correct because we know the when it comes to President, there is a Council of Ministers, and this Council of Ministers headed by the Prime Minister, and what these people will do, they will give aid and advice to President on all the matters. So now when it comes to appointment of judges of Supreme Court, the President need recommendations or the aid and advice of the Council of Ministers. But if they are asking recommendations, then it becomes the wrong. Okay, so what they need to do, the Prime Minister who heads the Council of Ministers, they will advise the President on the appointment of judges, but they will not recommend it. Okay, then the Chief Justice of India appointed by the President after consultation with such judges of Supreme Court, High Court is deemed. Yes, when it comes to judges of appointment of Chief Justice of India, the President need to consult with the judges of Supreme Court as well as the High Court. Okay, and this particular is the mandatory condition laid down in the Constitution. But when it comes to the appointment of other judges means who? The other than the Chief Justice. So that time he may consult with Chief Justice or not. Okay, so this is not mandatory for him. But when it comes to appointment of Chief Justice, he need to consult it. Okay, so here also all three statements become correct. Next question. It is about the consider following statement with respect to Chief Justice of India and the judges of Supreme Court. Okay, as per the Constitution, only the senior most judge of Supreme Court can be appointed as the Chief Justice of India. Then consultation of Constitution of India does not prescribe any minimum age for appointment as the judges of Supreme Court. Now both statements, if you see, it is saying as per the Constitution. Okay, as per the Constitutions, the senior most judge of Supreme Court will be the Chief Justice. So this is not correct. It is the practice or tradition. Okay, through this practice or tradition, the senior most judge of the Supreme Court will be appointed as Chief Justice of India. So it is not mandatory made by the Constitution. So this system, as many times it is dropped. Okay, 1972, 71, if you remember, when Keshwanand Bharti case came. So that time it was the larger bench. Okay, Keshwanand Bharti case. this was the larger bench sat to decide on Keshwanand Bharti case, and in that 9-judge bench, okay, this 9-judge bench, 13-judge bench, it was not 9, it was the this Keshwanand Bharti, it was the 13-judge bench. Okay, so in this 13-judge bench, many people who were about to become the Chief Justice because of this tradition that appointing the senior most judge as Supreme Court, Chief Justice of Supreme Court, okay, or the India. So the many people who voted in favor of Keshwanand Bharti, who voted in favor of laying down the basic structure of constitution, they were dropped. Okay, and some junior judge appointed as a Chief Justice of India. So there are the incidents when this practice was dropped. So it is not mandatory made by constitution, but it is by the because of the tradition or the practice. Okay, then second, the Constitution of India does not prescribe any minimum age appointment judge of the Supreme Court. This is the correct. Okay, so this controversy again erupted. It is in news because if you see the tribunal reforms, okay, when the government brought the Tribunal Reforms Act, that time what they said, to appoint, okay, for tribunals, a person wants to become the member of this tribunal, particular tribunal, then he must be age of 50 years. So this particular Tribunal Reforms Act, this laid down the minimum age criteria, that is the 15 year, minimum age should be 15 years. And against this one, this particular act, Supreme Court 2 times they dropped this particular, or they said this is the unconstitutional because Constitution has not laid down the minimum age for the Supreme Court as well as the High Court and for other courts also. Okay, so this becomes the wrong. So minimum age, it is still pending in Supreme Court, but government has implemented this act. But again, Supreme Court had to decide on that. That time we will see it. But remember, Constitution has not prescribed any minimum age for the judges. Okay, be it Supreme Court or High Court. So second statement is correct. Correct option will be B. The only 2 is the correct here. Then this one, with reference to oath and affirmation taken by the judges of Supreme Court of India, consider following statement. Okay, so first statement says the judge swear to bear true faith, allegiance to Constitution of India. Then judge undertake to uphold the sovereignty, integrity of India. The judge promises to perform his duties of office without fear, favor, affection, or ill will. Then judge swear to uphold the Constitution and the law of the country, law of India. Okay, so let me know which one is the correct here. Okay, so if we see all the 4 oaths that taken, okay, the judge, he will swear to bear the true faith, allegiance to Constitution of India. Yes, the judge undertake oath to uphold sovereignty, integrity of India. Yes, the judges promise to perform duties of office without fear, favor, affection, ill or will. Yes, the judge swears to uphold the Constitution of India and the law. So all this becomes correct here. Okay, so these all are 4 correct here. So if you see, these same oaths will be taken by the Prime Minister, okay, ministers, the CMs at state, the minister at state. So this same oath will be taken by the judges of the Supreme Court, and there is no separate oath for the Chief Justice of India. There is the only oath for the judges that mentioned in the constitution. Okay, let me know in comment section which schedule makes mention of the oath and affirmation. Okay, so correct option is D. 1, 2, 3, 4 are correct here. So here, consider the following statement regarding powers of parliament in relation to Supreme Court. Okay, so see, the privilege, leave and the pension of the judges of Supreme Court are determined by the parliament from time to time. Then parliament is empowered to regulate the jurisdiction, power and procedure of the Supreme Court. Then parliament is not authorized to curtail jurisdiction power of the Supreme Court. So now the fourth statement, if you see, it is giving the certain power to parliament. Okay, now when it comes to privilege, leave, pension of the judges of Supreme Court are determined by parliament from time to time. Yes, it is the power of the parliament. Okay, and this is the direct line from the Lakshmikant. So that's why when it comes to this privilege, okay, this leave, so when you see these kind of words, that time you might think that we have given the enough independence to the Supreme Court. So in that time, to privilege and the leave, it must be determined by the Supreme Court itself. But it is not in case the Parliament will decide the privilege, leave as well as pension. That is, we know the salary allowance also it will be determined by the Parliament. Okay, so first statement is correct. Then Parliament is empowered to regulate jurisdiction, power, procedure of Supreme Court. Yes, this is also correct. Jurisdiction means what? Previously, if you see now the example, writ jurisdiction. Okay, writ jurisdiction of the Supreme Court. So now writ jurisdiction of Supreme Court extend only to the fundamental rights and not to the other rights. Okay, other rights that might be constitutional rights. Okay, legal right. Here the writ jurisdiction of Supreme Court not extend. So the Parliament with the law can extend this writ jurisdiction to the other rights. Okay, legal rights, constitutional right. So that's why the Parliament will determine the jurisdiction. Okay, again the powers. Okay, what powers Supreme Court, High Court, Supreme Court will have. Okay, so the Parliament can say that when it comes to the deciding the disqualification of MP MLAs, that will be decided exclusively by the Supreme Court. So this original power that might Parliament give to the Supreme Court. Okay, now it is with High Court, but Parliament can give the power also. They can regulate this power or they can curtail this power also. Then procedure. Okay, procedure. So what kind of procedure? Okay, we have seen articles. Okay, 262, Article 262. Here we have seen their procedure also will be regulated by this Parliament. So Parliament has empowered to regulate jurisdiction, power, procedure of the Supreme Court. So now remember these three words. Okay, UPSC will ask question from here only. They will play with words. So when you see these two words, that time again you will think that it is the Supreme Court itself. But when it comes to jurisdiction, power and procedure of the Supreme Court, it will be regulated by the Parliament. Then last also, the Parliament is not authorized to curtail the jurisdiction power. Yes. Okay, because Parliament is not authorized to curtail means what? They can increase but cannot decrease. So decreasing the jurisdiction power of the Supreme Court, it is not in hand of Parliament. The Parliament can only increase. So previously, the Supreme Court not had jurisdiction over criminal matters. Okay, appellate jurisdiction over criminal matters. So Parliament given this appellate jurisdiction over criminal matters. Okay, so this is what they did. They increased the power, but the Parliament cannot say if they don't have criminal, they cannot be having the civil. So it is what? It is the reducing. So this is not authorized to Parliament. Parliament only can increase jurisdictional power. They cannot curtail it. So the last statement also correct. Correct option is D. 1, 2, 3 are correct here. The next one, with reference to tenure and removal of judges of Supreme Court, consider following. It is asking about the tenure and the removal of judges. Okay. Now the first statement, the Constitution does not fix a specific tenure in years. Okay. The Constitution does not fix a specific tenure in years for the judges of Supreme Court. Okay. The judge of Supreme Court can be removed by the President on the recommendation of the Parliament. Then the Constitution regulates the procedure for the removal of Supreme Court judges through the process of impeachment. So now see the all three statements carefully. Prima facie, all three statements looks easy and correct. But if we see, the constitution does not fix the specific tenure in years for judges of Supreme Court. Okay, what do you think? Is correct or incorrect? So it is correct, because Supreme Court has not told judges can hold office for 5 years or until the reach age of 65 years. This is not told by the constitution. They have just told the maximum age, that 65 years. Okay, till this age only the person can become the judge of the Supreme Court. Okay, it is not tell that maximum for 5 years. So what is says that the constitution not fix the specific tenure in years. When it comes to years, it is not fixed. So first statement is correct. Then judge of the Supreme Court can be removed by the president or recommendation of parliament. Yes, we know the procedure. Okay, the parliament will recommend. Okay, we'll see first last statement. The constitution regulate procedure for removal of Supreme Court judges through the process of impeachment. Now what will think? The constitution regulates? No, it's not constitution which regulates. It regulated by the Judges Inquiry Act. Okay, the power to regulate the procedure, it is given to the parliament by constitution, and according to that, parliament brought this particular act, the Judges Inquiry Act, and this particular act regulate the procedure of removal of Supreme Court judges through the process of impeachment. Okay, so that's why the last statement becomes wrong. Okay, this we'll see with the next MCQ. So the first option is here correct, that A is correct, only 1 and 2 are correct here. Then next, again it's Judges Inquiry Act 1968, which the parliament got power to regulate the procedure, and for that parliament brought this particular act. So now we will see the first statement. The motion for removal of judges of Supreme Court must be signed by at least 100 members of Lok Sabha and 50 members of Rajya Sabha. Then the motion must be passed in each house of parliament by majority of not less than 2/3 of total membership of that house. Then, unlike most parliamentary motions, the motion for removal for judges does not lapse on dissolution of Lok Sabha. Let me know which one is the correct here. Okay, so we'll see the motion for removal of judges of Supreme Court must be signed by at least 100 members in Lok Sabha and 50 members in Rajya Sabha. Yes, this is given in this particular act. Second statement, see, the motion must be passed in each house of parliament majority of not less than 2/3 of total membership of that house. This is wrong, because the what kind of majority that suggested for the removal of judges, it is the half of majority of total membership, majority of total membership. In addition to this, 2/3 present and voting. Okay, means what is the majority of Lok Sabha? Now we'll take Lok Sabha as example. It's 543. So what is the majority? It will be, must be 272. 272 members must vote in favor of impeachment motion. In addition to this, suppose if there are the 300 members present, okay, 300 members are present. This, out of this 300, 200 member must vote in favor of. Means what? These two conditions simultaneously fulfill, then only the motion of impeachment passed. Okay, supposed to be passed. So if you see this particular statement, the motion must be passed each house of parliament majority not less than 2/3. Okay, 2/3 means they are asking, in case of Lok Sabha, 2/3 of this 543, and this kind of majority applies to the impeachment of president. Okay, for impeachment of president, this majority applies, but when it comes to Supreme Court judges, this majority applies. So second statement is wrong. Then, unlike most parliamentary motions, a motion for removal of judges does not lapse on the dissolution of Lok Sabha. Yes, this is fact side note given in Lakshmikant that motion to removal of judges does not lapse or dissolution of Lok Sabha. Okay, so correct option is here 3. B, that 1 and 3 are correct here. Okay, before this, we'll briefly discuss the impeachment. Okay, the judges, this particular act, has given the some procedure. What is the procedure? The first is the motion of removal of judges of Supreme Court. Okay, in case of Lok Sabha, it must be signed by 100 members, and in case of Rajya Sabha, it must be signed by 50 members. Okay, after that, okay, if the motion is coming in Lok Sabha, speaker will decide. Okay, speaker will decide whether to adopt or not. If speaker decide it is unfair, he decides not to adopt, then motion lapse there. It will not go further. In case of Rajya Sabha, it will be decided by the chairman of Rajya Sabha, okay, or the vice president of India. These people will decide. Okay, if they're coming in rise. Now suppose both people have adopted. Now, if the speaker adopt, the speaker will establish committee, or the chairman adopt, chairman will establish committee. So there would be 3-member committee. 3-member committee. Okay, 3-member committee, and the 3-member committee will made up of, first will be judge of Supreme Court, then judge of judge of Supreme Court, Chief Justice of India, judge of Supreme Court or Chief Justice of any High Court, and third will be distinguished jurist. Okay, this person is also eligible to become a appointment as a member of the judge of Supreme Court. So that's why this condition is included here. So 3 people, it will be Chief Justice of India or the judge of Supreme Court. If it's impeachment motion against the Chief Justice of India, then the judge of Supreme Court will be there. If impeachment motion is against the judge of Supreme Court, then Chief Justice will be there. Then they can bring the judge of Supreme Court. Okay, if Chief Justice are there, they can bring the other judge also, or they can bring the Chief Justice of High Court, and third person distinguished jurist. Now these people will decide whether person suffers from misbehavior. Sorry, it's not misbehavior. Yes, it suffers from misbehavior or incapacity. So they will decide if person suffers from misbehavior and incapacity. Now, when it comes to misbehavior and incapacity, it is not defined in Constitution or not defined in this Judges Inquiry Act. Now, this misbehavior and incapacity will be solely determined by these people. Okay. Now they decide person suffers from misbehavior or incapacity, then they will recommend the speaker, okay, to consider the motion. When you will consider, it will be introduced in the Lok Sabha or Rajya Sabha, wherever it is originated. Okay. Now this particular house will pass with the majority of the total membership, in addition to this 2/3 present and voting. So after that, they will send it to second house. Same kind of majority will be followed. After that, this motion will be given to the president, and the president, how will remove? He will remove by order. The president will issue order to remove the judge of the Supreme Court. Okay, and the same procedure applies to the judge of the High Court. Okay, and also the members of Election Commission, Chief Election Election Commission of India, as well as the State Election Commission. So that time we will see this one. So remember, this is the procedure. Okay, everyone knows, but for revision purpose, I have discussed. Then next, regarding Supreme Court. Okay, the Constitution authorized the Chief Justice of India to appoint places other than the Delhi as the seat of Supreme Court. Then Supreme Court can on its own make the regulating rules, regulating practice and the procedure. It's the third one. The cases or reference made by the President under Article 143 decided by the bench consist of at least 5 judges. Now see the 3 statements. Now the Constitution authorized the Chief Justice of India to appoint places other than the Delhi seat of Supreme Court. Yes, but what he need? He need prior recommendation of president. Okay, but still first statement correct. Second statement, if you see, the Supreme Court can on its own make rules regulating practice and procedure. It cannot do on its own. What it need prior recommendation or consideration of president. It cannot do on its own. Same also, if Chief Justice want to change the seat of Supreme Court, he cannot do on his own. He need to have the prior recommendation or the consideration or the permission of the President of India. Okay. Last statement, the cases or reference made by the President under Article 143 decided by the bench consists of at least 5 judges. Yes, it is called as constitutional bench. Okay, and this constitution bench made up of minimum 5 judges. Okay, and this is condition laid in Article 143. So correct option is here. A, that 1 and 3 are correct. Second is wrong. Now see the role of Supreme Court. It is asking about role of Supreme Court. Okay, first it is highest court of appeal in country. Then it has act as guarantor of fundamental rights of citizen. Then the function as guardian of the constitution. Then ultimate interpreter of the constitution. Okay, let me know which one is the correct here. Okay, first statement says it is the highest court of appeal in country. Yes, it is highest court of appeal because we have seen first statement question itself. Okay, it is replaced British Privy Council as a highest court of appeal. Okay, we need to go to Supreme Court with highest court of appeal. Now the what you will be overthinking here, you will think person can go to the president to as a final appeal, but remember this is the executive power of president. Okay, pardoning is the executive power of president. It is not judicial. Okay, it is not judicial power. So that's why the Supreme Court is the highest court of appeal. Okay, it says that court. When it comes to if you go to the president for pardoning, the president not sit as a court. He will not sit as a court. He will be deciding based on his executive power. It will not hear it as a court. So when it comes to the court, it is the Supreme Court, which is the highest court of appeal. Second, it acts as a guarantor of fundamental rights of citizen. Yes, Supreme Court acts as a guarantor of fundamental rights. Now many will think High Court is same, but who has the original jurisdiction, original power? That is Supreme Court. So the Supreme Court is considered guarantor of fundamental rights of citizen. Now there is difference between original power and original jurisdiction. Okay. Now comes to original jurisdiction, the power lies with High Court, but when it comes to original power, it is the Supreme Court. Okay, that I have discussed in fundamental right chapter. Okay, third part, you can go and watch that one. Then it functions as a guardian of constitution. Yes, it functions as a guardian of constitution because it checks the unconstitutionality of particular amendment, constitutional amendment, as well as the law. So that's why it is considered guardian of the constitution. Then last one, it is ultimate interpreter of constitution. Yes, because Supreme Court is ultimate interpreter. Even the High Court interpret something, we can go to Supreme Court by way of appeal, and the Supreme Court will give the final shape to the provision of the constitution. So that's why it is called ultimate interpreter of the constitution. So all 4 statements are correct here. D is a correct option. Then this one, with respect to original jurisdiction of Supreme Court, original jurisdiction of Supreme Court. Okay, the Supreme Court's original jurisdiction means it hears certain disputes in the first instance, not by way of appeal. Then such a dispute must involve the question of law or fact on which existence extent of legal right depends. Then the suit filed by private individual against the union or the state cannot be entertained under the original jurisdiction of the Supreme Court. Quite simple question. The Supreme Court's original jurisdiction, what is the original jurisdiction? It means the certain disputes that Supreme Court will hear in first instance. and not by way of appeal. So that's why I called, when it comes to fundamental rights, okay, the original jurisdiction lies with the High Court. But when it comes to fundamental right, original power, this original power, it lies with Supreme Court. Why original jurisdiction with the High Court? Because when your fundamental rights will get violated, you have the chance or the opportunity to go to the High Court. If you think High Court is not decided properly, then you can go to the Supreme Court by way of appeal. Okay, so that's why it is not original jurisdiction. Original power because it can decide, it can give you final decision on the violation of fundamental right, or it can shape the constitutional provision accordingly. So that's why it is called original power. Okay, so first statement is correct. Original jurisdiction means the certain dispute that Supreme Court will hear in first instance, as well as not by way of appeal. Second statement, such a dispute must involve question of law or fact on which existence or extent of legal right depends. Yes, it must involve the question of law. Okay, then only it is considered original jurisdiction. Then last, a suit filed by the private individual against the union or the state can be entertained. It cannot be entertained. Okay, it cannot be entertained. If individual is going against the state or the union, okay, under the original jurisdiction, then it will not be entertained in Supreme Court. So the 1 and 2 are correct here, third is wrong. Okay, next is writ jurisdiction of Supreme Court. First let me see, the Supreme Court has original writ jurisdiction but not exclusive. Then Supreme Court can issue writ only for the enforcement of fundamental rights. Then President can confer upon the Supreme Court power to issue writ for the purpose of other than the enforcement of fundamental rights. All three questions we have discussed as a side note. Okay, so first statement is C, the Supreme Court has original writ jurisdiction but it is not exclusive. Yes, because not exclusive means why? The High Court also have the writ jurisdiction. Okay, the High Court has also given the writ power of writ jurisdiction, so that's why it is not exclusive. Then the Supreme Court can issue writ only for the enforcement fundamental right. Yes, Supreme, when it comes to Supreme Court, it can issue writ for enforcement of fundamental right, for the not other constitutional right or the legal right. High Court can do this. Okay, when it comes to High Court, it can issue for the fundamental rights, it can issue for the constitutional right, it can issue for legal right. Now what are the just brief side note, what constitute fundamental rights? That rights you have got from article 14 to article 35, these all are fundamental rights. Then what comes to constitutional right? One example is right to property. Okay, right to property is no longer fundamental right, but it is the constitutional right, it is the called as constitutional right. Then legal right, right to strike. Okay, you know, right to strike is not fundamental right under article 19, but it is the legal right given by the law. Okay, I forgot the name of the law, but it is the legal right. So this is the difference. Now when it comes to the fundamental right, this all fundamental rights are constitutional right. Okay, the all fundamental rights are constitutional right. Now all the fundamentals and the constitutional rights, they are legal right, but it is not vice versa. All legal rights are not constitutional right or the fundamental rights, or constitutional rights are not fundamental rights, but all fundamental rights are constitutional right, and all the fundamental rights and the constitutional rights are the legal right. Okay, quite confusing, but remember this one. So last statement we will see, President can confirm upon Supreme Court the power of issue writ purpose, that we have seen. It is not a president, by it will be by the Parliament. Okay, Parliament can give this power to Supreme Court, that to issue the writ for the constitutional rights as well as for legal rights. Okay, so last statement is wrong. Correct option is there. 1 and 2 are the correct here. Okay, we'll see. Consider following statement. Supreme Court primarily function as a court of appeal and hears appeal against the judgment of High Court. Okay, Supreme Court primarily hears the as a court of appeal hears appeal against the judgment of High Court. Then Supreme Court is empowered to grant special leave to appeal at its discretion from any judgment order passed by any court or tribunal in India. Then the Constitution authorizes the President to seek advisory opinion of the Supreme Court on question of law or the fact. Okay, let me know which one is the correct here. Okay. First advance, Supreme Court primarily function as court of appeal. Yes, it hears appeal in how many instances? First is the constitutional. You can go with the certificate from High Court that your issue is not decided properly. There is scope to interpret Constitution. Okay, so with this, in constitutional cases, you can go to High Court as a way of appeal. Then this criminal as well as civil matters. Civil matters, there is no fixed value. Okay, previously there was fixed value. Apart from that, you cannot go. Okay, to High Court. Now that is removed. Now criminal matters, two cases. Okay, when you get the capital punishment, that time you can go, as well as you will get this imprisonment. That is the, let me check once. Okay, imprisonment. This imprisonment for your life, if you got life imprisonment, as well as more than 10 years. So in these two instances also you can go. Third is the special leave. Okay, now this special leave is discretionary power. Okay, the Supreme Court empowered to grant special leave in its discretion from the judgment order passed by the any court or tribunal. Now this special leave, the Supreme Court by suo motu will take any judgment or the any appeal, okay, from the High Court, and it is the discretionary power. Okay, and this passed against not all the, it is passed against the any court but not any tribunal except the military one. So when it comes to military tribunal, this special leave, that power is not available to Supreme Court. So this statement becomes wrong. Okay, then last one, the Constitution authorized President to seek advisory opinion of the Supreme Court on question of law or fact. Yes, Constitution has authorized this. There is a two instances. First is the law and fact, and second is the matter of public importance. So the 1 and 3 are correct, second is wrong. Correct option is here C. 1 and 3 are correct here. Now see, the judicial review of the Supreme Court of India implies that it can. Okay, what is judicial review? The review modify its own judgment. Okay, review constitutional validity of legislative enactment and executive action. Then review functioning of subordinate courts on the administrative matters. Then review the innocent publications and criticism judicial act. So what constitute judicial review? This is the review the constitutional validity and legislative enactment of executive action. So this is the judicial review. Don't confuse between these two. This is not judicial review. Okay, it is the correction. It is judicial correction, not a review. First one. This is the previous year question. Okay, judicial review means it can review the constitutional validity of legislative enactment as well as the executive action, and that the both Supreme Court, Union government as well as state government. Second, this statement, if you see, the jurisdiction and power of Supreme Court with respect to matter in the union list can be enlarged by the Parliament. Okay, second, the jurisdiction and power of High Court with respect to matter in state list can be enlarged by the state legislature. Both seems logically correct, but see which one is the correct here. Okay, so now when it comes to jurisdiction power of Supreme Court with respect to union list, it enlarged by Parliament. Yes, it is correct. Now when it comes to the jurisdiction power of High Court, it enlarged by with respect to state list can be enlarged by the state legislature. It is not with the state legislature, but the agreement, there would be one agreement between whom, union as well as state government, and through this they will enlarge it. Okay, not state legislature itself. Okay, so second statement is wrong here. Correct option is here A. Only one is correct. Okay, now the regarding strength of the courts in India. Okay, first statement says that the strength of Supreme Court of India is determined by Parliament. The strength of High Court is determined by the state legislature concerned. Again, logical, but we have the integrated judicial system that we have seen. So when it comes to strength of Supreme Court is determined by Parliament, yes. Okay, and this is not considered as constitutional amendment under Article 368 that we have discussed several times. But when it comes to strength of High Court, it is determined by the state legislature. It is not correct. Who will determine? It will be determined by the president. Okay, so that depends on the business of High Court. Okay, but it is not by the state legislature. So remember this one, second is wrong. Correct is here A. Only one is correct here. From here onwards, we'll see the question related to High Court. Okay, now first statement if you see regarding the qualification of judges of High Court. So basically I will be comparing Supreme Court and High Court. So for that will be better for the purpose of revision. Okay, you will remember it. So now see, the person appointed a judge of High Court must be citizen of India. Okay, second, the person to be appointed a judge of High Court must hold judicial office in the territory of state. Then the person appointed a judge of High Court must hold the judicial office for the 7 years. Now let me know which one is the correct here. Okay, so first obviously the person must be citizen of India. No, so a person is not citizen of India, he is not empowered to become the judge of High Court or the Supreme Court. Second, the person appointed to be judge of High Court must hold the judicial office in the territory of the state. This is not correct. It is not territory of state, but it is the territory of India. So the person would have held the judicial office in the territory of India. So this is the correct wording there. Okay, and in addition to this, person to be appointed judge of High Court must hold the judicial office for the at least 10 years. It is not 7 years. So third also is wrong. So correct option is here A. Okay, so now when it comes to the Supreme Court, we all know the person must be, first he must be citizen. Second, he must be judge of High Court. Okay, sorry. When it comes to Supreme Court, first is that person must be citizen of India. Then second is he must be judge of High Court for how many years? It is the 5 years. Okay. Third condition that they have seen, the person must have it can be High Court or advocate. Okay. Now when it comes to judicial office, Okay, it is same applies. Then another one is this distinguished jurist. And who will decide the distinguished jurist? The person, it will be president. The in mind of president, the person must be distinguished jurist. So these are the conditions to become the Supreme Court judge. The next one is tenure of High Court judge. The Constitution does not prescribe fixed tenure for the judge of High Court. Then originally Constitution fixed age of the retirement of High Court for 60 years. Then any question regarding age of High Court is decided by the Chief Justice of the India consultation with the President. Okay, so again it here we'll compare. So first statement that the Constitution does not prescribe fixed tenure of High Court. Yes, we have seen the in Supreme Court also there is no fixed tenure in years, that is fixed by the Constitution. Then the original Constitution fixed the judge of age of retirement High Court at 60 years. Yes, originally it was the 60 year, later it is increased to the 62 years. So now what is the condition? That the person should not be age of more than 62 years. So 62 years is maximum limit to become the judge of a High Court. Then any question regarding age of the High Court judge decided by Chief Justice, it is not Chief Justice but it will be decided by the President. Okay, when it comes to High Court. Now when it comes to Supreme Court, who will decide this? It is the Parliament will decide. Okay, Parliament will decide when the question of age arises. And what is the in Supreme Court? What is the maximum limit? It is the 65 years. Okay, so these are the some comparison. So the last statement is wrong here. Correct option is here A. 1 and 2 are correct here. Then again appointment of appointments in High Court. First statement: the President can appoint judge of a High Court as acting Chief Justice of that High Court. Then Chief Justice of High Court is empowered to appoint duly qualified person as additional judge of High Court. Then Chief Justice of High Court can request retired judge of the High Court to act as a judge of the High Court. So now in these three cases, first is correct. President can appoint a judge of High Court to acting as the acting Chief Justice of that High Court. Then Chief Justice of High Court, it is not Chief Justice but it will be President. Okay, President will appoint the additional judges. Okay, but when it comes to the Supreme Court, it is will be done by the Chief Justice of India with prior permission of President. Last also, the Chief Justice of High Court can request the retired judge of that High Court to act as a judge of the High Court. Okay, yes, this is correct. Here, the Chief Justice of India can request the retired judge of High Court to act as a judge of High Court, but this also with prior permission of President. So the second statement is wrong. First and 3 are correct here. So the correct option is here A, that 1 and 3 are correct here. Then again next, jurisdiction and power of High Court. So see the Constitution does not lay down the detailed provision regarding jurisdiction and power of High Court. Then the jurisdiction and power of High Court mentioned in Constitution cannot be curtailed. Last one, the both Parliament and state legislature are empowered to modify jurisdiction of power of High Court by law. Now let me know which one is the correct here. Okay, see first statement, the Constitution does not lay down detailed provision regarding jurisdiction power of High Court. Yes, it is correct. What the Constitution says, it says the High Courts of the state, they will have the same power and jurisdiction that they had in the colonial time. Okay, so they are just succeeded to the same power and jurisdiction they got which they enjoyed during the colonial time. So this is same provision made by the Constitution also. So it is not laid down the detailed provision like it did for the Supreme Court. Okay, now this jurisdiction and power of High Court that they got from the colonial time, in addition to this, certain powers they got from the Constitution. Okay, so which kind of power? To decide on civil matters. Previously they not had two power to decide on civil matters. Okay, they got jurisdiction over the deciding on fundamental rights also through writ jurisdiction. So these kind of rights they got from the constitution. So these are the additional power or jurisdiction they got, but constitution has not laid down the detailed provision. Okay, when it comes to jurisdiction power of high court. Second statement, jurisdiction power of high court mentioned in constitution not be curtailed. Yes, this is the one case that made for to maintain independence and impartiality of high court, that the powers and the jurisdiction of high court that mentioned in constitution cannot be curtailed. It can be increased but cannot be curtailed. Last one, both parliament and state legislature are empowered to modify the jurisdiction power of high court by law. It is not both. The parliament is empowered to modify jurisdictional power, but when it comes to the high court, they will do with agreement with state legislature, but individually they cannot do on their own. Okay, that time they need each other's permission, okay, or each other's agreement with each other. So last statement is wrong here. Correct option is here B, that only 1 and 2 are correct here. Then original jurisdiction of high court does not extend. Where high court's original jurisdiction not extend. Dispute relating election of members of parliament, state legislature, local bodies. Then enforcement of fundamental rights of citizen. Then cases to be transferred from the subordinate court involving interpretation of constitution. The matters of admiralty and the contempt of the court. Okay. Where do you think the high court's original jurisdiction not extends? So in my opinion, first, here their original jurisdiction not extend, because the original jurisdiction of the high court extend to decide on the election of parliament, state legislature, but not on the local bodies. It will be solely state law. The state law and local bodies will authorize some authority, and they will decide on election of local bodies, not by the high court. So the first statement is answer here. Okay, A is the answer. So other three, B, C, D, here the high court's original jurisdiction extends. Next, the consider following statement regarding power and jurisdiction of high court in India. So the high court can issue writ to any person, authority, government for the enforcement of fundamental rights. Then appellate jurisdiction of high court is wider than the original jurisdiction. Then the high court has the power to superintend over all courts, tribunal within its territorial jurisdiction. Okay, now let's see which one is the correct. Okay, so see first statement, the high court can issue the writ to any person, authority, government for enforcement of fundamental right. Yes, it can issue the writ jurisdiction to private person, the administrative authority, as well as the governments to enforce the fundamental rights of citizen. Then the appellate jurisdiction of high court is wider than the original jurisdiction. Yes, we have seen where the original jurisdiction comes, this deciding election of member, the admiralty of the law. Okay, so these four conditions are there. But when it comes to appellate jurisdiction extends to the civil matter, the criminal matter, and if there is need of interpretation of constitution. Okay, so these are the wider jurisdictions. Okay, many items comes here. Okay, so that's why the appellate jurisdiction of high court is wider than the original jurisdiction. Then high court has power to superintend over all the court tribunals within its territorial jurisdiction. Yes, they have the power that. This is laid down by the one of the case that happened in 1991. So let me know the name of the case in comment section. So D is the correct option here. Okay, now this one is administrative control of high court over the subordinate court. So it can exercise control over appointment, posting, promotion of district judge in the state. Then it regulate posting, promotion, leave, transfer, and disciplinary matters or members of subordinate judicial service. Then judgments are binding on all subordinate courts functioning within its territorial jurisdiction. It can withdraw the cases pending in subordinate courts if involves the substantial question of law requiring interpretation of the constitution. So how many of above comes under administrative control of the High Court? How many of this comes under as a administrative control? Okay, so the administrative control of the High Court goes to with the these three conditions, that regulating posting, promotion, leave, transfer, or disciplinary matter of member of judicial service. Then judgment, that binding is judgment binding on all subordinate courts. Then withdrawing cases pending in subordinate courts. Okay, if it is involves substantial question of law or interpretation of constitution. Why this is wrong? Because it will give the recommendation, or governor will consult with High Court. Governor will consult with High Court when he will decide on the appointment, posting, promotion of district judge. So it is a not administrative control of the High Court. When it comes to governor's consulting governor, then it becomes the administrative control, but not on its own. So correct option is here only 3. C is the correct option. Again, now this one, Contempt of Court Act 71. Okay, so this will see the expression of contempt of court is defined in under the Contempt of Court Act 71. Then High Court has the power punish for the contempt itself as well as subordinate court. No High Court shall take cognizance of contempt of subordinate court if such a contempt is punishable under the Indian Penal Code 1860. So let me know which one is the correct here. Okay, so first statement, it is correct. The expression of contempt of court, okay, it is defined. It defined as civil contempt as well as criminal. Okay, that we'll see in detail next slide. Then the High Court has power to punish for the contempt of itself as well as subordinate courts. Yes, it can punish the contempt of High Court as well as subordinate court. Last one, no High Court shall take cognizance of contempt of subordinate court if such contempt is punishable under the Indian Penal Code. Yes, this is also correct. Because if certain offense is punishable under Indian Penal Code, then it will be decided by subordinate court as a offense only. So there is no need to take it as a contempt of court. It is the offense. Okay, so it will be decided by that court. So the all three statements are correct here. 1, 2, 3 are correct option. This we'll see briefly. Okay, what is contempt of court? Contempt of court 71. Okay, it is enacted based on recommendation of which committee? It is H.N. Sanyal committee. This is the previous year question. They ask mention the person. It is enforced based on the recommendation of H.N. Sanyal committee. Then what constitutes civil contempt? So we have seen the expression of contempt of court. It is defined in 71 Act. Okay, so it defines as civil contempt. What constitutes civil contempt? It is the willful disobedience of court order, court's decree, its judgment, breach of undertaking given to the court. Then what constitutes criminal? It is scandalize or lowers the authority of any court or interferes with the judicial proceeding. So what is the civil contempt? It is the just disobedience. Okay, disobedience to the court's order, its decree, its judgment, or the breach of undertaking that you give to the court. So this is just for civil contempt, that disobedience. But when you lowers the authority of the court, okay, or you interpret the judicial proceeding, then it is considered criminal contempt. Then it includes the publication of materials in any form, that is written, spoken, or the visuals, okay, that can be damage the court's reputation, hinders the administration of justice. Okay, when it comes to criminal content, okay, see, they will refer this publication of materials. Okay, the way of it is written in newspaper, or it is spoken, or through the visuals, though it is considered a contempt of court. Now the constitutional basis. What is constitutional basis? The Supreme Court and High Court are designated a court of record under Article 129 and the 215 respectively. So the High Court under Article 129 and Supreme Court under Article 129 and High Court under Article 215, they get the power as a court of record, and this also makes the constitutional basis for the contempt of court. Okay. Apart from this, the court of record maintains its decision for the future reference and possesses the inherent power to punish for contempt that outlined in contempt of court. Okay. So in court of record, the contempt, the matters they decided based on the contempt of court, it will be recorded, okay, or the possess it also for the future references. So this is the one. Now when it comes to procedure, how the initial procedure will be initiated, the process of starting contempt action is specifically defined in the contempt of court. So now the process is defined in Contempt of Court Act 1971. Okay. Now there is, when it comes to contempt of court, suo motu power is there. When it comes to suo motu power, the High Court or Supreme Court can initiate proceeding on its own motion. Okay. If it believes there has been contempt committed. Okay. So there is suo motu power, and there is a third party petition. When they will go for third party petition, the third party can also file petition. Okay. The third party, apart from the Supreme Court or High Court, but it requires the prior consent of Attorney General of India. So if third party is filing petition that there has been contempt of court, that time they need the consent of Attorney General of India for Supreme Court and Advocate General for the High Court. Okay, so this is the important. When third party files the petition that for the contempt of court, then that time it needs the consent of Attorney General in case of Supreme Court and Advocate General in case of High Court. Okay. Then now the punishment. The Act provide for the person found guilty for contempt of court the simple imprisonment up to 6 months and the fine up to 2,000 or the both. So if you do the contempt of court, you will get 6 month imprisonment or the 2,000 rupees fine, or you can get the both. Okay. So the court, there is a power that the court may exempt the accused if satisfactory apology is offered. So if satisfied, the court will give you chance to apologize for that. If you is given the satisfactory apology, then you will be exempted from this punishment. So this is the important thing. Last one is a very important, that court has power to exempt also, provided you apologize for that. Then next question. Okay, so the power to review High Court. Okay, power of review of High Court in India. What is the power? As court of record, High Court have the power to review, correct its own judgment, orders, or the decision. Okay. Then unlike Supreme Court, the Constitution has not expressly confirmed the specific power of review on High Court. This is a previous year question they asked in, I guess, 22. So first statement, the court of record, High Court have power to review, correct its own judgment, order, and decision. Yes. Now second statement, if you see, unlike Supreme Court, the Constitution not expressly confirmed the specific power of review on High Court. This it is correct. Constitution has not given expressively this power, because we have seen Constitution has not given detailed provision of jurisdiction and power of High Court. So when it comes to this judicial review power, that is not specifically mentioned in Constitution, but when it comes to Supreme Court, it is specifically mentioned. So this statement is also correct here. Correct option is here C. Both are correct. The next statement, next question. Judicial review in India. The expression of judicial review is not explicitly mentioned anywhere in Constitution. Then the High Court have the power to examine the constitutional validity of both central as well as state legislative enactment, as well as the executive order of. Then the 42nd Constitutional Amendment debarred High Court from the examining the constitutional validity of any central law. Okay. So all statements are correct. The expression of judicial is not explicitly mentioned anywhere in Constitution. That is correct. Then High Court have the power to examine constitutional validity of both central law as well as the state law, including the executive actions of both. Then 42nd Amendment. Yes, it is debarred High Court from examining constitutional validity of central law, but again subsequently this power restored. Okay, so the all statements are correct here. The D is a correct option. Okay, with this we have finished High Court as well as Supreme Court. Next session we'll see the tribunals. Okay, then subordinate courts, the lok adalats, and the gram nyayalaya. Okay, another 3-4 sessions we'll be finishing this complete Indian polity sessions. Okay, for today, thank you very much.